Good afternoon, everybody. Glad to have you. Glad to have you here today. So I was asked by Visoa to do a presentation on the new Fire Safety Act, and so this is just basically it's a high-level look at the Fire Safety Act and strata corporations. So my name is Kathleen Nicholas. I am the principal of Artemis Fire Consulting Incorporated. I have almost 30 years in the life safety industry, starting back in 1997. I'm also the founding secretary back in 2019 of the Vancouver Island Fire Protection Association, which is the first of its kind in Canada, where it brings together all of the different stakeholders in the life safety industry, including everybody from building inspectors to fire departments to annual inspection providers to everybody in the manufacturers. So I'm very proud of the fact that we've gotten everybody together to talk on the same page. And I think one of the largest unidentified challenges for strata corporations is that they are bearers of the ultimate legislative responsibility for life safety in their buildings, both under the BC Building and the BC Fire Codes. However, they often have little or no knowledge of the acts, regulations, and standards that govern them. They have been given the ultimate responsibility with the least amount of education or support. I liken it to having given the keys to the school to the kindergartners. And I mean that with all due respect, because you guys have a lot on your plates. So that brings us to a discussion about the new Fire Safety Act. And that was also, which also again places that ultimate responsibility for life safety on the shoulders of the owners. So while the act was given royal assent in 2016, it did not come into force, replacing the Fire Services Act of 1996 until August of last year. It has a 1-year transition time with full implementation in place by August of this year. In the words of the Office of the Fire Commissioner in their letter to Building Owners and Managers Association, they stated, "The Fire Safety Act and the associated regulations will be essential to protecting people and communities through regular fire safety inspections and effective enforcement that will help prevent fire-related tragedies, preserve human life, and reduce property and economic loss due to fires." The Office of the Fire Commissioner worked with many organizations, including the Union of BC Municipalities, Local Government Management Association of BC, the Fire Chiefs Association of British Columbia, and the Ministry of Municipal Affairs for BC, to support the government policy direction to establish a single standard of fire safety for the whole province. Now, the backbone of the Act is as follows. The FSA meets the BC government's commitment to achieve a single standard of fire safety in the province and will enable local authorities to designate personnel to carry out fire inspections and fire investigations and enable local fire services to perform tactical evacuations. In the previous Fire Services Act, it was assumed that fire department personnel would hold those positions. But the new act allows for more flexibility, which is often necessary in regional districts, which often have volunteer firefighters and no dedicated prevention personnel. So this would allow regional districts, for example, to designate individuals to act as fire investigators or as fire inspectors who aren't necessarily firefighters, is a great way of putting it. It will also establish an administrative penalty enforcement model to address non-compliance issues in a more direct, timely, and effective manner. This is a significant change, and with municipal adoption into the local bylaws, it will give teeth to fire safety enforcement that didn't exist in the former act. Will also lead to the implementation of a risk-based approach for fire safety compliance monitoring in municipalities. This will be based on occupancy type as well as previous compliance. So under the FSA Part 620, the FSA will be implemented by monitoring entities, which are defined as municipal councils, but does not include regional districts. So, for example, Courtney, I believe, is a regional district. Cowichan Valley is a regional district. Municipalities will operate within a risk-based compliance monitoring model, which means that their designated fire inspectors will be responsible for conducting all fire inspections. Regional districts are not defined as monitoring entities in the Fire Safety Act and have identified resource and administrative challenges which may prevent them from undertaking fire inspections and fire investigations in their areas, because of the fact that they have, say, volunteer fire departments or no dedicated fire prevention personnel. As regional districts are not monitoring entities, they will operate within a reactive, meaning complaint-based or owner-requested inspection framework. The Office of the Fire Commissioner has committed to performing fire inspections and fire investigations on behalf of the regional districts at no cost to them. However, the regional district with sufficient resources and local expertise may choose to undertake all inspections and investigations within their districts. So, what is a risk-based compliance monitoring system? The purpose of this system is to determine if an owner of a public building within the boundaries of a monitoring entity, which we've defined as a municipality, complies with the Act itself and the regulations that is based on a risk assessment analysis conducted in accordance with the regulations, and that consists of fire safety inspections and fire safety assessments. A monitoring entity may charge the owner of a public building a reasonable fee for conducting a fire safety inspection, as long as the fee is imposed by bylaw. And this is one of the parts that's really important about the new Fire Safety Act. The Act itself stands and says, here's what's going to happen, but much of it must be adopted into the bylaws of the municipality or the regional district, to be enforceable. Let's put it that way. I can say that the City of Victoria, for example, their fire prevention division is currently working on redrafting the fire bylaws so that they can be adopted by the city and incorporate the new Fire Safety Act requirements. So, what do we mean when we talk about fire safety assessments? With the implementation of the FSA, there may be a requirement, and I use the word may be a requirement for building owners, including Stratas, to conduct a fire safety self-assessment annually that will be implemented by the local municipal government. As a result, premises owners may receive requests from the monitoring entity, the municipality, to complete a fire safety self-assessment report for their property. To assist owners with this new requirement, the Office of the Fire Commissioner is developing a Fire Safety Act self-assessment manual. This manual is primarily intended to support the building owner or the building owner's authorized agent in completing a fire safety self-assessment and declaration. When asked about the liability ramifications of having an untrained individual, such as a council member or property manager, conduct such an assessment, a representative for the OFC confirmed that they took no position on that issue and that owners would also be free to have another agency or company complete the assessment on behalf of the owners. Now, we were very fortunate. Actually, a few questions were sent to us as we were preparing this presentation, and they dovetailed rather perfectly with what we were wanting to discuss. So I've included them here. First question was, how often does the fire department generally come around to do inspections on buildings? Under the FSA, generally once a year for residential occupancies. However, that may change with the implementation of the new FSA risk-based assessment model and how municipalities choose to implement the requirements of the risk-based compliance. Under the FSA, a residential building is considered high risk and in need of inspection once per year. Number two, are all companies who perform fire safety inspections and do maintenance to fire safety equipment in light of the new FSA required to send the results, a report, to the fire department? Both the BC Fire Code and the new FSA require that all reports and paperwork be available for review by the AHJs, meaning the authorities having jurisdiction, in this case, fire departments. The easiest way to fulfill that requirement is to A, have your service provider send you reports, including repair reports, not just your annuals, but your repair work that's done each year. Send those reports directly to the fire department. And B, keep a copy of the 2 most recent years and repair reports in your fire safety plan under their own tab. Fire safety plan is the book that nobody looks at in a box near the front door. You are not fulfilling the requirements if only your property management company is receiving the documents, but not installing them on site. So for example, here, if we look at the BC Fire Code, a statement that very few people recognize or realize is number 2211, responsibility, which states that unless otherwise specified, the owner or the owner's authorized agent shall be responsible for carrying out the provisions of this code. So remember when I said we asked the kindergartners to hold the keys to the school? Here you go. All of the owners in the buildings are actually responsible for the implementation and enforcement of the BC Fire Code within their building. There is also, of course, the information there about the records. So the responsibility to keep all test, inspection, maintenance, or operational procedures shall be kept and shall be made, and the original or a copy shall be retained on the premises for examination by the AHJ. You're also required to keep your verification and test reports for each system are to be retained throughout the life of the system. So if you have an existing fire alarm system and then you have that pulled out and replaced by a new one, that new verification report needs to be kept for the life of the system. And as we said, you're required to keep at least 2 years worth of reports on site. However, the Strata property regulations require that you keep all records related to life safety equipment for the life of the equipment. So that can become a very large file if your building is 30 years old or is going to continue for another 30 years. But only the 2 years, most recent years, need to be in the fire safety plan for access by the AHJs. And then we talk about inspection powers. So under the FSA, the inspection powers for fire inspectors spells out the requirements to have documents available. So also under the FSA, the fire commissioner has the ability to impart administrative penalties under section 33 if satisfied that someone has failed to comply with an order made under, the fire inspection orders or the preventative evacuation, or if they contravene 10.6 inspection powers and investigative powers. So this is saying that the fire inspectors must be able to view any documents they wish to view when they come to your site. Failure to produce those documents for them, can lead to administrative penalties imposed under this section, including amounts not greater than, for an individual, $25,000, and for a corporation, $50,000. Now, presumably, this would only be imposed upon those who repeatedly fail to provide their documentation, but it is a big stick if you are not complying. So next question, is there any relationship between the new FSA, Fire Safety Act, and other regulations like the NFPA 25? This particular person had been told that NFPA 25 governs what testing and maintenance needs to be performed on their building. This requires its own page to unpack some information and to clarify a couple of things. So first, I'm going to talk about the difference between acts and regulations, codes, and standards. So acts and regulations tell what needs to be done by whom and sets the bar for that work by referencing standards. So examples of acts and regulations are the Strata Property Act and regulations that both control repairs, maintenance, financing, and report retention. The Fire Safety Act and regulations, which replaces the BC Services Act of 1996. Codes spell out both what and how things need to be done. So example of codes include the BC Building Code and the BC Fire Code. Both of these are adopted from the National Codes of Canada, with tweaks to them to make them provincially applicable. The most recent code updates were both adopted in 2024. from the now official national code to which all of the provinces and territories in Canada have ascribed. This is the first time that this has happened, and they will be continuing at this process in the future. In the past, some provinces adopted all or only part of the codes, and there was no consistency across the country. And finally, standards are the how and are referenced by the codes. They spell out the specifics of how to accomplish the code-defined requirements. So the installation, replacement, and alteration of life safety equipment building in a building is covered by the BC Building Code, which references many standards for the various equipment and materials that are installed on site. This will include standards that tell, for example, how high to install pull stations and heat detectors, to the coverage requirements for smoke detection in hallways and air ducts, to the need for sprinkler systems, elevator homing, and independent monitoring, and so much more. Once the building is built, however, the BC Fire Code takes over, mandating that the installed life safety equipment must be inspected, maintained, and repaired according to the standards that apply to each system. Oop, bounce. So examples of the governing documents include the most important one that most people are going to be, if you're a multi-unit building, familiar with would be the CAN ULC S536, which is now the 2019 version. This is the standard for inspection testing of fire alarm systems and the most common one, especially if you're in a multi-unit building. This is closely followed by S552-14, which is the standard for maintenance and testing of smoke alarms, which you would find inside of your suites. Those are the local detection only. They do not set off the fire alarm system. They only beep inside your suite. And there are specific testing standards for those. S1001 is something that most people are not familiar with, and this one only happens sporadically. So during the initial verification of all of the systems that will be affected or activated by the fire alarm system, but which are not part of the fire alarm system. So this would include elevator recall or homing that is tied into the fire alarm system, air handling unit shutdown, generator interconnections. Those are just a few examples. But there are lots of things that happen in the building that may be connected to and triggered by the fire alarm system, but are not actually part of the fire alarm system itself. So this testing is done in the first year of verification, and then the second year after verification, and then every 5 years after. No one has been doing this, and many buildings have never had integrated system testing done, but it is a requirement in both the BC building and fire codes. CSA C282, emergency electrical power supply for buildings. For all the folks with not only generators, but battery operated emergency light units, all the testing falls under that category. And then, of course, we have NFPA, the standard for portable fire extinguishers, and NFPA 25, which was the original question was about, is actually the standard for the inspection, testing, maintenance of water-based fire protection systems, which covers both sprinklers and standpipe systems. So next question, does the new FSA apply to a building solely based on its construction and occupancy date? No, it applies to all buildings, whether residential or other occupancy, no matter when they were built. However, the type of occupancy and assigned risk level will affect the frequency of those inspections. Now, I know this is very tiny. I hope you can see it on your screens. So under the fire safety risk analysis for compliance monitoring regulation, each major group occupancy classification is assigned a general risk level. Strata buildings fall under group C, which is down here, residential occupancy, and they are defined as a high risk level, primarily because of the fact that they have folks sleeping in the building overnight. And you don't have a lot of people around to look after the building, as opposed to, say, a care occupancy, where you have elders living. They often have a lot of care people around, and therefore they're considered a lower risk because you have those people always awake and moving around. And then to determine the frequency of inspection and assessment, the monitoring entity, meaning the municipality, in consultation with their fire prevention departments, is entirely responsible for determining the frequency of fire safety assessments and fire inspections, though both processes must be included in the monitoring entity's risk-based compliance monitoring system. The frequency decision for both processes shall be based on the monitoring entity's risk analysis completed in accordance with the legislation and regulation. The best practice, the monitoring entity performs an initial fire safety inspection to identify risks and confirm a building's overall risk rating. This is also going to be based on information the monitoring entity will, based on this information, the monitoring entity will determine the frequencies of fire safety inspections and fire and safety assessments for that building. So if we were strictly to go by the table provided here, the occupancy risk is considered high for a strata building, and the specific risks looking at the building, so looking at its age, condition, history of compliance, and occupant behavior, chances are high it's going to be considered moderate or high, meaning it will still require an annual inspection by the fire department. And it may also, they may decide that an actual safety self-assessment is required as well. But again, I say we have yet to find out. Does the new FSA stipulate that upgrades must be done to buildings with older equipment, i.e., built under an earlier building or fire code? Remarkably, no. But let's unpack that a little bit. This, once you're built, the secondhand building essentially becomes Sleeping Beauty. Years pass, codes change, but as long as you don't touch her, i.e., do work that requires a building permit, those changes to the code will not affect your building. In the case of your fire alarm system, as long as it's still, quote, operating as originally designed and intended according to the code of the day, you're home free. That being said, a lot of older buildings have fire alarm systems that are now obsolete. And despite the fact that they're still operating, they are no longer supported by the manufacturer. You can't get new parts, and secondhand parts at best are coming from eBay with no guarantee. As the old saying goes, failing to plan is planning to fail. So if you see the words recommend a fire alarm upgrade on your annual service report from either your service provider or the fire department, take it seriously and start your planning immediately. Why? The cost of Firewatch, should your system fail, is astronomical. Having the Corps commissionaires walk your building 24 hours a day for a month will cost about $35 an hour, or $25,200 plus taxes per month. And the final question that was provided was, will owners or strata council need to sign a declaration every year that the building they own is compliant with the new FSA? And that's yet to be seen. As we've discussed, the FSA allows the authorities to request that owners provide a fire assessment, safety self-assessment of their building each year. What does that look like? Well, as we discussed, we have yet to find out. The Office of the Fire Safety Commissioner is still in the process of creating a self-assessment document that owners will be able to fill out. What will include, at minimum, we can assume that will include the information currently found in your fire department annual inspection report, but we don't know for sure yet. So now that we know a bit more about the FSA and how it might operate, let's cover what happens if you don't comply. The FSA defines offenses under the Act, including any person who obstructs, hinders, or interferes with a fire safety inspection, fire investigation, or evacuation under this Act, or B, provides false or misleading information required to when required to provide information under this Act. When I spoke with the South Island field representative for the Office of the Fire Commissioner, I specifically asked about this section because for the first time, it appears to give the kind of enforcement teeth that is currently only found in the Alberta and Ontario Fire Acts, though not as explicitly. When I asked if this applied equally to the owners and service providers in their buildings, he said yes. And this is interesting because the owners are now going to be relying even more heavily on their service providers' reports when they engage in doing the safety self-assessments that they may be required to provide to the fire department annually. So how are they to know if their reports are accurate? That all tests and inspections required are being carried out. This should be made simpler in that all fire safety companies are now required to use the ULC designed and mandated forms without change or exception. But are all companies using those forms and conducting inspections correctly? Strata councils and owners are unlikely to know. But I can tell you that if right now, if you're receiving a CAN-ULC S536 annual inspection report, and it is less than 27 pages just for the fire alarm system itself, chances are it's not the ULC compliant forms. And the penalties are not light for these offenses. So, for example, failure to or giving false or misleading information, $50,000 or a year in jail for an individual, and $250,000 for a corporation, which is what both the service providers and the strata corporations are. You are corporations. Now, the good news is that at least the Stratas have a wee bit of a get out of jail free card in that you are going to be relying on reports from professionals. And you can honestly say that you were misled and exercised reasonable due diligence and care in passing on the reports that you had received. But that doesn't do much for the technicians and service companies who are using, inadequate reports or not doing the full work that they're supposed to. In this case, following the ULC formatted documentation and ensuring that technicians are provably well educated and experienced could become essential to limit liability, not just for the service providers, but for stratas as well. The fines will also accumulate as long as the offense is ongoing. The time limit for laying in information, so actually the fire commissioner jumping in to say you've done something wrong, is 3 years after the date on which the act or omission that is alleged to constitute the offense occurred, or if the fire commissioner issues a certificate regarding the issue, 18 months after the date on which the fire commissioner learned of the act or omission. Oops. It would be much harder for the technician service companies to employ them to claim that they didn't know that information was false or misleading, as this is their profession and they ought to have known. In this case, following the ULC formatted documentation and ensuring that technicians are provably well educated and experienced could be essential to limiting liability. So what effect does this have upon stratas? It will take time for stratas and their owners to absorb all this. And as all of you know, council members are volunteers. I have yet to read a strata insurance policy that covers volunteers for conducting monthly testing of fire alarm systems, undertaking safety self-assessments, or acting as fire safety directors, but those are best left for another day. You've been subject to a significant amount of legislative change over the past 2 years that has quite dramatically changed the conditions under which you are required to operate. There is reason to anticipate a good deal of resistance to new FSA requirements, but we encourage all of you to take a positive approach by waiting to see how your local municipality or regional district implements the changes, and when possible, by engaging professionals who can help to mitigate your risk and limit your liability when it comes to life safety. Want to learn more? Do take a look at all of this information online. I'm pretty sure you'll have additional resources or links on the VISOA website. And there are also great public-facing documents regarding the Fire Safety Act and regulations at the above address. Every document that they have created to discuss or explain this new act are up on that website, including some great frequently asked question documents, which really dig down a little deeper into the act itself. And I encourage you, especially if you're a fire safety director, go take a read, because it's important that you understand. And that's the sum total of what I have to cover today, but I am very open to answering any questions about life safety stuff that you might have.
Thank you so much for being
You're
our guest
welcome.
today.
You're
I'm sure
welcome.
everyone learned a lot. And can you just, you mentioned that people could send you questions.
Sure, you can contact me via email at admin. Oh, I can even I'll put it into the chat too. It is admin at Artemis, like the goddess, fire.ca.
Okay, well, thank you again so much. And
You're
thank you
welcome.
to all of our members for joining us today.